One of the passive-aggressive ways that employers handle requests for reasonable accommodation is by delaying taking action until we either lose our temper, which they can then spin as a conduct problem, or until we give up and go away. And the sad truth is, once they've decided to drag their feet, there's not much we can do about it. We can try being extra accommodating and hope that they'll meet us halfway, but that didn't work for me. The best option I could find was to document the delays, so at least I'd have evidence of them at my hearing. Now, employers seem to believe that they can get by with delay, but this week I found a couple cases where delay tactics bit employers in the butt, so I'd like to share those with you. McRae versus Wilkie found that an unreasonable delay in providing reasonable accommodations can constitute a failure to accommodate all by itself under both the ADA and the Rehabilitation Act. And the McRae decision says that whether or not a delay was unreasonable depends on the totality of the circumstances, considering 5 factors: the employer's good faith in attempting to accommodate the disability, the length of the delay, the reason for the delay, the nature, complexity, and burden of the accommodation requested, and whether the employer offered alternative accommodations. And after considering all those factors, if the judge decides that the totality of circumstances resulted in an unreasonable delay, that's failure to accommodate all by itself, even if they eventually provided you with the reasonable accommodations you requested. A lot of the factors mentioned by the McRae judge were also mentioned by my EEOC AJ in his decision deciding that NASA had unreasonably delayed taking action on my request. McRae was a black male who drove a passenger van for the Veterans Administration. He developed some knee problems, and VA's own ergonomics team said that it was because the van he was driving was too small for him. He was 6'3", so as reasonable accommodation for his knee, he requested a different van. And it shouldn't have been a big deal because according to McRae, a lot of white women in his office who had requested new vans for reasons that weren't medical had gotten them. There were plenty of new vans around. But it still took VA 6 months to act on his request. And the van they eventually gave him was worse than the van he had in the first place. It was even smaller. The power steering didn't work. The horn didn't work. The windshield was cracked. It jerked when he put it into gear, and it had a lot of other problems too. He requested another van as reasonable accommodation, and another 6 months later, he finally got a suitable van. The VA's defense was that, hey, we eventually gave him the van he requested, so we reasonably accommodated him. Initially, the district court said, yeah, that sounds good, and they sided with the VA. But McRae appealed that decision and eventually won his claim for failure to accommodate because the VA took so long to get there. But at least McRae and I survived. This week, I learned about a case where the person being strung along didn't survive. DeFranco versus the city of Chicago. DeFranco was a cop working with the narcotics unit of the Chicago Police Department. He had cystic fibrosis, a permanent and progressive lung disease, and he had diabetes associated with that. In March 2020, COVID lockdowns were just starting, mandated by Illinois' governor. The police department's communications office sent out an email to all employees saying that anyone with an underlying health condition that put them at risk of serious complications from COVID should contact the medical section immediately to discuss the next steps, presumably to discuss reasonable accommodation. DeFranco contacted them right away, and his doctor's office sent his medical records that same day. He tried to follow up with the medical section every day, but they never answered any of his emails, and their voicemail box was perpetually full. Meanwhile, DeFranco kept working, and after just about a week, he started experiencing symptoms of COVID. And within a couple days, he heard that 3 officers that he'd had to work with during that week had already tested positive. Now, despite his illness, DeFranco kept trying to call the medical section to arrange reasonable accommodations for the future. They never returned any of his calls, although they did provide reasonable accommodations to some other people, including some people whose requests were submitted after DeFranco's. And just about 2 weeks after DeFranco initially contacted the medical section, he died of complications from COVID. DeFranco never filed a claim with EEOC. His widow did that on his behalf. The city of Chicago tried to have the case thrown out. They claimed that an estate couldn't bring a discrimination suit on behalf of a decedent, and EEOC policy was on their side. But the 7th Circuit, who heard the case, said they weren't bound by EEOC policy. They were only bound by the law. The next thing they did was claim that DeFranco was treated the same as everyone else, so there was no disparate treatment, therefore no discrimination. But the Seventh Circuit said that was missing the whole point of a failure to accommodate claim. The law actually says that we disabled workers have the right to ask to be treated differently because of our covered disabilities. And our employer is obligated to act on our request in a prompt manner. So the Seventh Circuit allowed DeFranco's widow to take his case forward, which is at least a partial victory. She's still fighting, and she's caught up in a huge tangle of red tape, so I hope she gets some justice soon. It's encouraging that courts recognize that delaying reasonable accommodations can have the same effect as not reasonably accommodating us at all. But until employers get that and start acting differently, the best option we employees have is to document the delays and try to hang in long enough to get some kind of compensation for the harm their delays have caused us. To do that, we'll need evidence that shows things like how long our employer delayed, what their reasons were for the delays, and that those reasons were either ridiculous or made up, that providing us with accommodations sooner wouldn't have been hard, that they could have provided us with alternative or interim accommodations but didn't, and other evidence that our employer may have acted in bad faith. And I have a video about that I'll link at the end of this one, so hang around. You guys may disagree and tell me in the comment section if you have some other options, but I think it's a very bad idea to waste time and energy trying to make a bad employer act right. They're not going to do it. So the best thing we can do is gather our evidence and try to prove what they did so we can nail them in court. That's what I got today, guys. I'll see you in the next one. Till then, take care and hang in.